Hi, Brian Foley here. I am a criminal defense lawyer here in Conroe, Texas, and I help people who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. We are going to be continuing our short lecture series on the rules of evidence today. Today's rule is Rule 104. And Rule 104 is called Rule 104 Preliminary Questions. So what's a preliminary question? It means like a suppression hearing. So when there's evidence that one side in a lawsuit wants to enter into evidence and the other side says, no, that's not allowed under these rules, then Rule 104 guides the judge on how to make that determination. Again, it's similar to Rule 101, which talks about when the rules apply, and the rules don't apply at a preliminary hearing like this. And so it says, in general, the court must decide any preliminary question about whether a witness is qualified, meaning are they do they have mental competence to the point where they can be a witness, or whether a privilege exists, meaning like the marital privilege is a good example of that. A husband would not have to testify against his wife. A wife would not have to testify against their husband, except for in cases of family violence. Whether evidence is admissible, like we said earlier. Let's say maybe there's a problem with the traffic stop and you want to say that the state wants to say the defendant was speeding, so that got them to pull the vehicle over. Then they smelled marijuana, that allowed them to search. Well, if you want to argue about that and say the car didn't really smell like marijuana, they weren't really speeding, boom, we'd be here at a suppression hearing under the preliminary questions for Rule 104. And then in so deciding, the court is not bound by evidence rules except those on privilege. So even at one of these hearings, you still can't call husband to testify against wife or vice versa. Let's see. So conducting a hearing so that the jury cannot hear it. You know, this is such an obvious rule to lawyers. We're always asking for the jury to be excused from the courtroom. And the reason is so that we can talk about stuff on the record with the court reporter there, but so that the jury can't hear it. Like, for example, dismissing evidence in a criminal prosecution, or the state will sometimes ask it because they want to introduce evidence. So let's say the state has some bad acts, some prior crime that the defendant has been convicted of, and they want to tell the jury about this prior crime. Well, they can't just do that in front of the jury. They have to ask permission, because any lawyer who's worth his salt has asked for a motion in limine on that exact topic. So they'll use Rule 404B to try to make some kind of argument about why they can enter in this conviction, and they'll do so outside the presence of the jury, and that'll be a preliminary question hearing just like this. Here's another good part of this rule. Subsection D, cross-examining a defendant in a criminal case. By testifying outside the jury's hearing on a preliminary question, a defendant in a criminal case does not become subject to cross-examination on other issues in the case. So this means that you have this special right to testify in a criminal case about the reason and the legality of the traffic stop or the search, if it was a house, something like that. So let's go back to that example of a traffic stop and finding marijuana in the vehicle. Well, if the police, let's say, pulled you over for speeding and they said that the vehicle smelled like marijuana, you say it didn't smell like marijuana, and instead of finding marijuana, they found, I don't know, heroin, okay? Well, there's a decent argument there that maybe the car did not smell like marijuana. Maybe that's not true, or at least there's not evidence of it sufficient that the judge would allow the other evidence found in the car to come in. So as the defendant, you would have the right to testify about what happened leading up to that search. And the prosecutor could argue with you and say, well, you were really speeding here because of this. They could ask you cross-examination questions like, well, hadn't you smoked marijuana in the car recently, even though there wasn't any found? Or maybe your friend could have. Whatever, they could ask you questions about that because that relates to the legal issue in the preliminary question. But they couldn't ask you like, well, isn't it true that you knew the heroin was in the center console? You know, stuff that relates to the substance of the crime. And that's what they mean when they say the criminal defendant does not become subject to cross-examination on other issues in the case. It's limited just to that focus for the preliminary question. The same thing would be true if you were trying to argue about a conviction. Let's say the prosecutor wants to use a conviction of a felony under Rule 609, and that says, you can use those to impeach credibility of a witness. Well, if it's more than 10 years old, there's a balancing test that needs to be done, and it's possible you could put the criminal defendant on the witness stand. I probably wouldn't advise that on that issue alone. You can probably just argue it. But in theory, you could put the criminal defendant on the witness stand and have him explain that preliminary issue, and they would not be subject to cross-examination on other issues. So that's a really cool part for criminal law in specific. I hope you've enjoyed today's mini lecture on Rule 104 of the Texas Rules of Evidence.